suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And guess what? You've got 2.5 lawyers today for the price of one. David Whiting, of course, is with you, well-known Melbourne solicitor, here to help you out. David, good morning.
Good morning, Virginia.
Great to see you. But joining you, David, and you can do the introductions for us, is...
Andy Hines, who's with work experience at Whiting Lawyers. So,
Andy Hines, how nice to meet you. Good morning.
Good morning.
You're in Year 10, I understand.
Yes.
Do you intend to go on and study law?
Hopefully, yes.
Why?
I've just sort of been interested in the subject, and I think doing work experience will get me just more of a gist around what they do and how they do it.
Exactly right. So are your employers being nice to you?
Yes.
They are. You have to say that. Look, and this is, I've got to bell the cat here, David. This is pure, flat-out nepotism. He's your nephew.
Understood. And he's getting very good at photocopying too.
I guess when you run your own company, you can hire who you like, right?
Indeed.
Yeah.
That's the way it works.
Well done. Well, you're working, as you know, with one of the best. What's he like as an uncle?
Very good.
Yeah. What's the nicest thing he's ever done for you?
He's never done anything for him. Virginia.
Yeah, no answer.
Maybe
Your
work
worship.
experience.
Maybe work experience might be. The photocopying might actually end up being the highlight of the relationship. 1300 222 774 if you have any legal problems that David Whiting can help you with. Any homework?
I did. I had Glenn from Richmond. Glenn from Croydon. Glenn had bought a Caravan. The Caravan was less than 6 years old, but he bought it privately.
Yep.
And the issue is he believes there's a major safety defect in the Caravan. And the question was, does the Australian consumer law give him any remedies against the manufacturer? And the answer is yes, if there's a safety defect that leads to loss and damage.
Right.
Glenn from Croydon has a claim against the manufacturer and can bypass the person he bought it from.
How do you prove that, though, the defect?
It's collapsed. The frame on which it has been constructed has collapsed. So he'll need some engineering confirmation that it's a design fault, and then he has a claim against the manufacturer.
Okay.
That's in addition to whatever warranty was given by the manufacturer at the time. 1300
222 774. We're going to start with Adam in Altona. Adam, hello. What's going on?
Oh, hi, David.
Yes, Adam.
Yeah, hi. Sorry, I just had an intriguing thing with my mum the other day. She went to change her will, and which was fine, and the lawyer said, he found a little clause in there. Do you remember signing this thing with your husband that you promised to never change it?
Yes.
And I just found that intriguing.
There's a concept called an agreement to make mutual wills, and I'll make my will your way, and in return you'll make your will in agreed terms. So it happens more often than not in second relationships, Adam. And it's kind of like, so I will say to a new partner, I will leave you everything, but you've got to promise to give some of it back to my children when you die. That's when it occurs. And what happens is there's nothing that technically prevents your mother changing her will. But the people who were benefiting under the other, I take it that her husband has died?
No,
Does the marriage come to an end?
No, they're still living together.
So what you would normally do is go and do a new document, another mutual will, again, so that they make another set of promises rather than a unilateral change.
Oh, yeah, he's got dementia, so I don't think he could.
Well, then the question... So what happens is if your mother changes her will and as a result the beneficiaries under your father's will, under the old will miss out, they have a claim against her estate for what they lost out on.
Okay, no problem. Okay,
Does that help?
Thanks for clearing that. Okay. Oh, yeah, I was just more intrigued that you could do that.
Yes, you can contract to make a will in a particular form.
Right, okay.
Yep.
And unless you then go ahead and make an agreement with the person you made that original agreement with, you can't make the change?
No. And so what usually we're talking about a situation where somebody dies and they've left you you've left the will in a particular way in the expectation that something will follow.
Yes.
So it's the expectation that you get the right to enforce.
Okay. Let's hear from John in Middle Park. Hello, John. What's happening? How can we help?
Yes, I did a silly thing. I picked up my mobile phone whilst I was driving and got booked for that. And in doing that, it will take me over the number of 12 points, which means that I would lose my licence. I'm self-employed and work by myself, so if I lose my licence, I won't be able to work. So I was wondering what's best to approach it. Should I, what's your advice?
You're going to get a letter inviting you to extend the period.
Okay.
Right. Now, if you extend the period, I think it's for a period of a year, but you can't get a point.
Right.
You can't get a speeding ticket. You can't get anything that gives you an infringement point.
Right. Okay.
Right.
And that's even because I think the points for using my mobile phone was 4 points, which will take me to well over the 12.
So how many will it take you to?
It will take me to 15.
Wow. I certainly
I
understand.
was on 11.
Yeah, but John, it seems to me that, you're I'm not sure how much sympathy I have.
I understand that,
Yeah.
and it's my own
I
fault.
didn't want to say anything.
There's
I'll
no
leave
one
it
else
to
to
David.
blame but myself.
Yes.
I understand, John, that you'll still get the offer, but you can't misbehave for a year. But I will confirm the rules next week. I tried to look at this for a client about a month ago, and the legislation is not clearly drafted.
It's not.
All right?
Okay.
But you're done for it. I'm sorry, John. But you won't get the letter till after I talk to you next week.
All right. So listen in.
Okay.
Thanks, John. Thanks for calling in. I'm sorry about that. Yeah, look, there's not a great deal of sympathy, I've got to say, in this studio for that repeated issue. It does come up again and again on the lines. Yep. And I think it's probably because, well, for very strong reason, because we are all aware of the aftermath and the consequence of doing that when it goes terribly wrong.
Of being distracted, yes.
And it goes wrong in the worst possible way.
Agreed.
So that's the thing to actually bear in mind. You won't find much sympathy for that here. Graham in Chelsea. Hi, Graham. Go ahead.
Hi there. Yeah, about a year ago, January last year, I had a police visit telling me that my car registration number had been left under the windscreen of a car, claiming I'd run into him.
Yes.
I couldn't recall having touched anything as I parked the car or moved the car away. So I said I'd be happy to pay if we can just establish that there is, in fact, some damage. Had a look at my car, couldn't find any damage at all, and asked them if I could see their car to match up damage on my car and their car and see if we could work it out, and asked who the person who witnessed the thing was, and they said they didn't know. Now, 18 months later, I've got a letter of demand from a credit collector from the insurance company.
Yes.
Wanting $850.
Yep.
Um,
Their problem, Graham, is that they need to prove it was your car on the balance of probabilities. And
Right.
if what you're saying is correct, the only evidence they've got is a notation under your that somebody put under their windscreen. So
That's
the police
correct.
are doing nothing about it because they can't satisfy themselves as to the prosecution.
Yeah, that assured me that they weren't planning on booking me or anything.
Why don't you try and go back to the people and say, can I have a photograph of the damage of the car? It could be that it's a different paint colour. It could be all sorts of things that could make this go away very quickly. Right?
Yeah, right.
And you'll then, by looking at the amount of damage to the other car, you'll have some idea of the damage that ought to be to your car.
Yeah. Well, the other car. Oh, yes. Look at the photo. Yeah.
Yes.
All right.
Yeah,
So
I can
that's
do that.
what I would be looking for, and go back to them and say, no, not me. It might be a try on, you don't know. But they ought to be telling you what evidence they've got that says it's your car. So ask for a photo and evidence as to what they say your car was.
All right. I hope that's helpful. And come back and let us know how it goes, Graham. Nice to hear from you. 1300 222 774. Andrew, who's called in near Warrigal. Go ahead, Andrew.
From Rugby?
I'm sorry?
From Rokeby.
Rokeby, okay.
Which is a long way from Warragul, isn't it?
I'm sorry.
Yeah.
Not far.
Okay.
10 minutes.
My mistake.
10 minutes from Warragul. Yeah.
Thanks. Okay.
Thanks, Virginia. David. We've got a daughter who's got a lifetime disability, so we bought for her to live, managed for her to support her daily living. And we have put in our wills that it's for her lifetime benefit, that if anything occurs to us, that the value of that goes to her. And we pay land tax, and why I support the government's revenue grab versus when I'm trying to support a daughter.
Yes.
Sorry?
You're one of the few who are willing to support the government's revenue grab, right?
Oh, look, I understand if it's an investment. I understand their idea that we should...
Andrew, the problem is the property's in your name.
It is, because Cass can't manage any of her affairs. We have a VCAT order to do financial affairs.
So you're stuck with it, I'm afraid, Andrew. It's not a question of what the purpose of the land is. The answer is it's a residential property in your name and comes up in land tax. Now, what you might consider doing is leaving it to her in your wills under a trust arrangement, and under that basis you would be able to get primary principal place of residence exemption for her from that time. But if you were to transfer the property to her now, which you could, so you could transfer it to her and with a loan back to secure the dollar value.
Any financial affairs, and then we'd also... So
they're the things that you need to play at. But your answer is that the land tax is payable in that situation.
Okay.
All right.
I'd ask. Thank you very much.
Okay, good luck. Sorry about that. Christopher in Richmond has got you might find this problem, David, a little confronting, but let's have a listen. Christopher, good morning.
Good morning. I'm ringing, thank you, David, for taking my call. I'm ringing for some advice on behalf of my grandsons. Their father has dementia, and I have evidence that he's had it for at least 5 years and maybe a little bit longer. But he has dealings with a lawyer who he's done business with, property transactions and whatever not, and the lawyer has the enduring power of attorney.
How old is the enduring power of attorney, Christopher?
I'm not exactly sure because, as far as I know, the lawyer hasn't given any account, but I suspect it was done before the dementia was diagnosed.
Yes. Okay. Can I say there are two challenges you can make? The first one, you're not going to be able to... So you would normally challenge it either because there was lack of capacity at the time it was made.
Yes.
And the second way, and that would appear not to apply in your circumstances, but the second way of challenging it would be to say that it's being used inappropriately or badly or not in the donor's best interest. So that's the argument. You'd go to VCAT and you would make an application for revocation of the power of attorney on the grounds that it's not being used in the donor's best interest.
What about the lawyer involved being asked to account for his activities? I mean, can he give are they entitled to?
No, the only person entitled is the donor, the person who hasn't capacity. Now, so the answer to that question is no. The only person who would be able to request an accounting would be the person who's now got no capacity.
No, he has no capacity.
No. So your application might be to, I mean, why not revoke the power of attorney? Why not make the application to revoke the power of attorney and see what comes out of that process?
Yes, that's possible. I do suspect that he did that some time ago because he had significant dealings with this lawyer, and that I know that the lawyer's continuing to take a salary for his activities, but there's absolutely no accounting for property transactions and whatever else that have gone on since
VCAT, the guardianship listed VCAT is where you take the process, but you need to come along and say it's not being used appropriately.
Okay.
All right?
We'll leave that with you. Christopher, good luck, and we hope that works out. Boris in the Yarra Valley's got a particular challenge. Hi, Boris, go ahead.
G'day, Virginia, David, Andy. Hey, I've just moved into an apartment in Carlton North with my partner probably 3 months ago. We haven't ever had consistent hot water in the apartment. And so we've gone to a real estate agent. They've said it's a body corporate issue. I'm pushing the case with body corporate. I just want to know, how far can I actually push this to actually get hot water consistently in our apartment?
What's the situation with the hot water? How is it being serviced?
In terms of being serviced, so there's 2 boiler units that basically supply the 20 units in the block. So it's a hot water system that runs throughout the entire entire accommodation.
Okay.
And yeah, we just I don't know if that's. I mean, I feel like having hot water is pretty basic.
I would agree with you, Boris. But it's the owner's corporation, and the level of the hot water is a decision made by the members in the owner's corporation, and you're looking for a substantial upgrade, I would guess.
Yeah. I mean, I know I'm being an annoying tenant, but we've just moved in there and we're paying a lot of rent, so I feel like...
So it might be... But your landlord has very little ability. He's one of 30. Your landlord only has the ability to speak in favour of the change. So,
yeah, no, absolutely. It's not something that we're going to our landlord about. I'm speaking to the body corporate about
it. No, but it might be a basis for terminating the lease on the basis that you're entitled to hot water, you're not getting it, therefore you want to leave.
Well, we don't want to leave. We love the apartment. We just want hot water.
I understand, and your landlord can't give it to you because he doesn't supply it. That's your essential problem.
As a tenant, we don't have any right to demand hot
yes,
hot
but
water?
only from the landlord,
right? Okay.
Not from the owners' corporation.
Right. Does this not bother the other members of the owners' corporation if they're living there as well?
Yeah, I mean, we've spoken to a couple of different neighbours, and they do get the same issue. But I guess, I guess
they get up earlier and live with
it. They use it all before us, probably. Yeah,
it's the 5 a.m. shower for you.
Okay, all right.
Sorry, Boris.
Thank you.
Or a choice is made. What do you like better, the apartment or more consistent hot water? And as you say...
It's a tricky question.
It
depends on whether it's summer or winter.
But if they decided to leave, that would be an allowable reason to get out from the lease.
There'd be an argument about, how bad is the hot water? Yeah. I mean, you probably also need to some form establish that the volume of the boiler is never going to work for 30 units.
I think that's more the point, isn't it?
Yes.
2 boilers of maybe that's standard. I don't know if anyone's listening and can tell us that's standard. Maybe the boilers aren't just working effectively. There's also that needs to be looked at.
You don't know how old the building is. You don't know any of those things.
Got someone in the other day to have a look at the heating.
Yes.
Just to have a look at it.
Yeah.
And I've got to tell you, the power of professional services, right?
Yes.
So this guy comes in and all of a sudden the heating is just working so much better, more efficiently. We're using it less often. The house is warmer just because someone came in and did a bit of a tweak.
Well, okay. Good luck, Boris. Go and find somebody.
Go find someone to have a look at it. All right. Richard in Heathmont. Hello, Richard. Go ahead.
G'day, David.
Hello.
My daughter lost her partner last year in a road traffic accident, and he was party to a VCAT dispute. He died pretty much without any money, and my daughter it was suggested that my daughter apply for letters of administration for the estate. He died intestate.
Yes.
The money that was there has been distributed basically to pay debts. There's now a $16,000 tax debt to the estate, and there may be some other debts due to this VCAT problem. I've been told that my daughter may be personally responsible for the debts, and because there's no money in the estate. And I'm wanting to understand how that could be and to what extent she may be liable personally.
Okay. As a general proposition, an executor or an administrator is not responsible personally for the debts, but they have to apply the funds in the way that they are required by law to apply them. So it's not, I've paid the first debt, they got paid in full, no one else gets a cracker. So right. It's a question of how much money was there and what are all the claims.
Okay.
So it's a question of looking at the Bankruptcy Act to see what the priorities are. So the first priority is the costs of the funeral, the interment. Secondly is the administration costs, and then whatever's left is generally to be distributed amongst all creditors in proportion to their claim.
Okay, that's what we haven't done.
Well, I understand, but you're only going to be liable to the extent of the shortfall.
Oh, okay.
All right, not the extent of all the claims. So let's be really silly. Let's assume there was $50,000, and after and the total claims against the estate are 80, and you went and spent $40,000 on something else, you're not going to have to put in all of the shortfall, because no one was going to get 100 cents in the dollar.
Yep. Okay.
Okay.
Yeah,
right. So it's not as bad as it sounds.
Well,
it's really a question of the priority in which you've done them, and then what you're able to do is negotiate individually with each of them, and you might get some people to just go away.
So it's going to have to be a series of calls and a bit of work done here then. Okay.
Yep.
We wish you and your daughter all the best. That's a difficult situation to be in. Thanks for calling in. Let's hear from Peter in Coburg. Peter, what's happening? Good morning.
Good morning. Hopefully a simple question. My mother's passed away, an estate divided into 5. We have a brother that's non-contactable. We think he's overseas. We haven't seen him for 7 years, and we have no way to contact him. We've tried, but we just can't contact him. How long do we need to hold it in the estate for him to make a claim upon it?
Well, it's really your obligation to find him, not his obligation to find you. What the law requires you to do is to give it to the State Revenue Office as unclaimed monies.
Okay.
And if you've incurred costs in trying to find him, you are able to deduct the cost of the search, successful or unsuccessful, from the amount you're paying him.
And in terms of obligation of looking for him, like needle in a haystack, like we just don't know. He's made no communications with our family.
I understand, but often there'll be a cousin or there'll be someone who has some link. Now, if you're satisfied that your network and people you know who knew him can't find him, then look on the State Revenue Office website for details in relation to unclaimed monies, and you give it to the state government, and for a period of years he can claw it back from them.
We know this person is alive, Peter?
Possibly not. Again, we just don't know.
There's also a process for assessing. How much are we talking about, Peter?
Probably once we sell the house, I guess, maybe 300,000, I guess.
Right, then what you might be looking at, and listen for next week, is whether or not there might be a possibility of get a declaration that he died. In which case, your executor would, if he's died, it's likely that the 300,000 will be redistributed amongst other family members.
Yes, but if he hasn't died, is there a time, like it's placed in that trustee and then it becomes back to the common estate?
No, it's a question of being satisfied that he's died. It's his until he's died, and if he dies, then it goes to someone else.
So you just.
But if he never claims that money, does that then return to the estate?
No. If there's clearly, if he's already died, then there will be something in the will about who gets it in those circumstances.
Yes.
If you do not know that he has died, then the process is to go to court to get a declaration that says, I want to be able to treat him in the administration of the estate as having died.
Okay, fair enough. And he could think, but he could think...
No, I'm trying to defend the position of the executor. In this circumstance, my concern is the executor. I don't want the executor to be sued. Now, your executor can say, Fred, I can't find, so I'll give it to unclaimed monies, or I'll go to court to get a declaration that I can treat Fred as dead.
Can't we do a little more work here to find out whether he's dead or alive?
Well, that's my point. My point is you've actually the court's going to want to be satisfied that you've tried really hard to find him.
I think we need to try a bit harder here and actually, search up some records.
Enough.
No, exactly,
But he could be overseas. We don't know anything.
Sure, but that's the work and the challenge of being an executor, correct?
Yes. Yeah.
That goes with the job. Peter, good luck.
Thank you.
Thank you. But, you're quite right. You don't want the executor to be in the position of, how they're having distributed or hung on to it and actually not done the right thing.
Yes, which takes us to the call before from Richard, who had the same problem of I paid the wrong person.
Just before you go, what's the legal consequence of that if you really do get it wrong?
Executor would be personally liable.
Meaning jail or fine?
No, $300,000.
Which is just floating around down the back of the couch, really. A pleasure seeing you, David. And Andy, what did we learn today from your Uncle David Whiting?
A lot of small legal questions, and didn't realise how much you knew about the law, obviously. Everything.
You just brought him here to impress your nephew, didn't you, David?
Absolutely, Virginia. I wanted him to meet you.
Oh, is that what it is? Yeah. I don't think that's the attraction. You're quite right. He knows a hell of a lot about a lot, which is why he's been doing this longer than any presenter who has actually sat in this chair. How about that? Great to see you, David. Good luck, Andy. Nice to meet you.